push it in?
Okay.
Testing, testing.
Just wanted to do that.
Everybody's working?
Testing, yeah.
You just have to hit the one, I think. I don't know what the left one's for, but let's see. There you go. Yeah, maybe it stays in there. Oh, that's weird. I don't know why both ears gone. Ready to go? All right. We'll call the April 15th ZBA meeting to order. Roll call, please.
Board Member Anderson? Here. Burke?
Here.
Bueno?
Here.
Chair Bavacqua?
Here.
Vice Chair Kirkendall?
Here.
Board Member McClellan?
Present.
May?
Present.
All accounted for.
All right, next item is official communications. Do we have any official communications?
There are no official communications at this time.
All right, and next item, minutes for review. Does anybody have any questions, concerns, notes about the minutes?
So the minutes are actually going to be included within the next ZBA meeting, as they are not present for this one.
All right. So the next item is approval of the agenda. So we move on to old business.
And the old business here, we have the case variance ZBA 23-021. Applicant's name is Jeremy Sutton. And if we could please just ask everyone to silence their phones. But that address is going to be for 404 Highland Avenue, and our planner, Paul Harang, will be presenting on that today.
Okay, I guess before we get started, I just wanted to take us through the process here. We're going to start out with a presentation by the administration, and then we'll go to public comment. And during public comment, just make sure that we allow the public to speak, and if the applicant wants to engage or address anything that's said by the public, they can wait until they have an opportunity to speak during their presentation. After public comment, we'll move on to presentation from the applicant, and at that time, we'll let the applicant present, and please do not interrupt the applicant. So I guess if we could have the administration provide their analysis.
Well, good evening, everybody. Again, this is a Zoning Board of Appeals April 15th meeting. Variance ZBA 23-021. Applicant Jeremy Sutton on behalf of Pontiac Highland Avenue LLC. Address 404 Highland Avenue. Parcel ID 14-18-427-016. Request number 1, 24-foot front yard setback, building setback. Request number 2, 2,307 square foot attached accessory structure. The applicant is seeking 2 variances related to a front yard setback and an accessory structure over the maximum square footage limit. As you can see, this is the location map, and this is the M1 concourse right here. This is Highland Avenue, and this is where the structure is located. Now, the next slide is the zoning ordinance. As you can see, zoning map rather. As you can see, the property is located right here in the R1 district. This is South Boulevard right here. Again, Highlands right here. This is a commercial P1 R1 district. Overview. Request variance number 1. The applicant is seeking a front yard setback of 24 feet. The requirement in an R1 district is a front yard setback of 25 feet. Variance request number 2. The applicant is requesting to establish an attached accessory structure with 2,307 square feet. The requirement for the accessory structures in an R1 district is up to 800 square feet. Background information: the property located on Highland Avenue between Nebraska Avenue and South Boulevard is subject to a variance request from section 2.403 and 4.101. After initiating construction, the applicant received a stop work order. Structure consists of a 3,507 square foot single family dwelling with 1,220 square feet in living area and 2,307 square feet in garage space. This is the timeline of events that was in your package. Now, this is a slide of the structure itself. As you can see, this is Highland Street. And then there's the two garage doors. There's also a garage door at the rear. Roughly, the garage extends from around here all the way back, and this area going along this side of the house all the way back is roughly where the single-family piece of the structure is. Now, this slide right here, the red outline is the primary structure right here, and the orange outline here, which I think is sort of yellow, is the property, which is 3 parcels combined into one. This is the floor plan for 404 Highland. As you can see, 2 garage doors here. This is the garage structure here. There's a garage door right here. Then this would be the living area right down to about there. And again, the residential is 1,220 square feet, and the garage structure, or portion of the structure rather, is 2,307 square feet.
Where's the road? That's not in our map. Where's the road? on
Sure.
that? Just for-
Right here.
Okay,
That's Highland Avenue. Yep.
thank you.
Now, these are standards of approval, 1 through 7. Obviously, you're familiar with these based on your package. So standards of approval variance number 1, front yard setback, number 1, whether compliance with the strict letter of the restrictions governing area, setback, frontage, height, bulk, lot coverage, density, and other dimensional or construction standards will unreasonably prevent the owner from using the property for a permitted purpose or will render conformity with such restrictions unnecessary, burdensome. The analysis is the lot size is typically roughly 150 foot deep by 150 feet wide, and originally was platted as 3 lots and now combined into 1. In staff's opinion, the existing lot at 0.52 acres is large enough to accommodate the principal dwelling with plenty of space which meets the setbacks. While the original plans displayed the building meeting the setback requirements, the variance is being requested because the building was constructed 1 foot into the required setback, contrary to the plan submitted. Standard number 2, whether a grant of variance will do substantial justice to the applicant as well as other property owners in the district, and a lesser variance will not give substantial relief to the applicant, as well as be more consistent with justice to other property owners in the zoning district. Analysis, the applicant is requesting a 1 foot variance. The city has established setbacks to ensure the buildings are constructed an adequate distance from the property lines and consistently the roadway and neighbors' properties. While this 1 foot offset may seem marginal, it moves the larger building, primarily containing the attached accessory structure, closer to the road and the residential homes across the street. Number 3, whether the plight of the applicant is due to unique circumstances of the property. Analysis, in staff's opinion, because the lot is large enough at 0.52 acres, there are not unique circumstances that inhibit the property owner's ability to comply with the setback regulations of the ordinance. Number 4, whether the problem is self-created. Analysis. In staff's opinion, the variance requested is self-created. The building plans submitted required the building to be constructed with a 25-foot setback, and these plans were not complied with. Additionally, there are not any unique property issues that would require the building to be constructed within the required setback. Number 5, whether the spirit of this ordinance will be observed, public safety and welfare secured, and substantial justice done. Analysis. In staff's opinion, approval of this variance, even at 1 foot, will provide special treatment that would likely not be given to other applicant. Now, this is number 6, whether there is compliance with standards set forth in section 6.401B. As you can see, in consideration of appeals and proposed variances to this ordinance, the zoning ordinance of appeals, zoning board of appeals, before granting any variances to this ordinance in specific case, first determine that the proposed variance will not impair the adequate supply of light, air to adjacent property or unreasonably increase the congestion in public streets and so forth and so on. Analysis. Section 6.401B seeks to protect the surrounding vicinity from any detrimental effect on property values, public health, and welfare. Because of the larger size of the property and size of the setback variance that has been requested, staff feels that there would be marginal impact to surrounding neighbors. Now, this is 7, as of course there's 7 standards involved in this. Whether there is compliance with standards for discretionary decisions as contained in section 6.303. Analysis on, in staff's opinion, this structure and the setback encroachment do not appear to meet standards 2 and 3 contained in section 6.303. Due to the character of the surrounding residential homes and reducing the setback requirement increases the impact to neighboring properties. Now, this is standards of approval for variance number 2. This is, of course, attached structure size, attached accessory structure size. Number 1, and I'll go over this a little quicker. Number 1, again, is where compliance will be strictly letter to the restrictions governing area setback, frontage, building height, lot coverage, density, and other dimensional construction standards. The analysis is the lot size will typically be, again, roughly 150 feet deep by 150 feet wide, and originally was platted as 3 lots that were combined into 1. The size of this lot does not prevent the applicant from being able to reasonably use the purpose as a residential property. Number 2, whether a grant of variance will do substantial justice to the applicant as well as to other property owners in the district, and a lesser variance will not give substantial relief to the applicant as well as more consistent with justice to other property owners in the zoning district. Analysis. Residential homeowners in the R1 district would not normally be able to build a 2,307 square foot accessory structure, attached or detached, larger than the principal structure. This variance request appears to provide relief to the property owner, but not the adjacent property owners on this block and within the zoning district. Number 3, whether the plight of the applicant is due to unique circumstances of the property. Analysis. In staff's opinion, a 150-foot deep by 150-foot wide lot. This is larger than typical lots in the city. However, the size of the lot does not justify the need for a larger accessory structure. Number 4, whether the problem is self-created. Analysis. The variance requested appears self-created as there are not unique property issues within this request that would necessitate a 2,307 square foot attached accessory structure, roughly 1,500 square feet larger than what the zoning ordinance permits. Number 5, whether the spirit of this ordinance will be observed, public safety and welfare secured, and substantial justice done. Analysis. Approval of this variance appears to provide special treatment that would not be given to another applicant in a residentially zoned property. Number 6, whether there is compliance with standards set forth in section 6.401B. Again, this is in consideration of all appeals and all proposed variances to this ordinance. The zoning board of appeals shall be granting any variance to the ordinance in a specific case. First, determine that the proposed variance will not impair adequate supply of light, air, and so forth and so on. Analysis. Section 6.401B seeks to protect the surrounding vicinity from any detrimental effect on property values, public health, and welfare. Because of the size of this building in an R1 zoning district with the attached accessory structure, it is much larger than what would normally be allowed under the zoning ordinance. The increase may impair public health, comfort, and welfare of the surrounding residential properties based on the character of construction and storage of vehicles. Additionally, staff is concerned that an increased accessory structure area may impair comfort, safety, and welfare of surrounding properties, as this type of use may give the appearance of a commercial storage of vehicles, which is prohibited in residentially zoned properties. Number 7, whether there is compliance with the standards of discretionary decisions as contained in section 6.303. Of course, you're familiar with the 7, so I will go on to the analysis. In staff's opinion, this request does not align with the special exception procedures of section 6.303 because of the following analysis of those standards. With standard number 1, the 2014 master plan classifies this property as traditional neighborhood, which is defined as the traditional neighborhood residential designation is intended to be a form-based district that is a district that regulates development by its form rather than its use. However, the predominant use in this area should be residential. So recommendation, staff only provides analysis and does not provide recommendation on variance requests. If the ZBA feels the applicant's request meets the standards of approval, they may consider approval of the variance. If the ZBA feels the applicant's request meets the standards of approval, they may consider approval of variance with following conditions. If the ZBA does not feel the applicant's request meets the standards of approval, they may consider denial of the variances. And these are the motions. And that concludes my PowerPoint.
Thank you. I'm going to at this time open the public hearing and remind the public that we have a 3-minute limit on public comment. Is there anyone who'd like to speak? Please state your name and address. And turn on the microphone. Thank you.
Good evening. My name is Robert Bass. I live at 499 Highland. I'm the president of the Citizen District Council in District 1. And we're asking that this council do not approve this variance, either one. And we've been on this ever since the first polls went up. We've been fighting this for over 4 years. And how they've been doing. It's not so much the building itself. Now it is, because what I'm seeing is allowances that were not okayed in 2020 when this was first done. I have the inspection report for everything that was done to that, even up until and after the cease and desist order. And nothing in here it okays him to build what he wanted to build, which was an oversized garage. It was supposed to be an attached house on the north side of the end of that building. Now you want to include the attachment on the inside. That's inclusive, that's not exclusive. So you want to use the inside of that garage and put a living quarters in it with cars sitting in there. And I don't think that's feasible. None of us felt that was feasible, but that's up to you. However, with all the violations that they had up until this point that they never addressed until now, you want to get a variance when it's in court. It's in 2 court cases. And we're hoping to get that settled at court. So to now want to get y'all to approve him to do some more work, to me, is inconceivable, because bottom line, he didn't do anything in 4 years. What makes you think that if you approve, he's going to do something now? Unless there's a court saying you got to do this, that, or that, then we're not accepting of it. They've tried twice to get us to concede and let them finish building or have a variance. We said no then, we're saying no now. Thank you so much for your time.
Is there anyone else?
Yeah, my name is Carlton Jones, 1323 Oakland Drive. This property is over in District 1. I'm a resident of District 1, lifetime resident of District 1. And I know everybody has a particular right to try different things, but let's keep it real. We know that R1 is the most restricted district of zoning in the code book, and it's the most protected. So any type of after effect appeal is out of place if it's not fitting for R1. And I say what I heard in the presentation was these issues were self-inflicting. So I don't see any reason. This should be a no-brainer. Now, if we have to, as Mr. Bass was talking about, we have to deal with this in the court, so be it. But this should be a no-brainer for you guys, to be truthful, because we realize what's going on. What's across the street is car condos. So now if you're going to move into an R1 and build what is somewhat semblance of a car condo, that's why we got zoning. And R1 is not where you come and put an oversized garage and try to make it out to be a house. Thank you.
Good evening. I'm Andrea Mans. I live at 432 Highland. So this building, this pole barn is next door to me. And my main concern is setting a precedence, because I know people that's been in Pontiac a long, long time, and they've requested to build structures on their property. And they've been long-time taxpayers, and they've been denied. So they were not even allowed to put it up, and they've came back 2 or 3 times to request to have something just as simple as a regular garage built, and they've been denied. And then here comes somebody, you know, out of town and buy some property, and they get to build what they want. And that's a concern that I have. You'll be sending out a message and setting a precedent, and you know, the people that live here, that's been living here paying taxes, they won't be happy. We'll be disappointed, you know, because we've tried and we've done things by the rules. So it's just something to take into consideration.
Is there anyone else who'd like to speak? Seeing none, we'll close public comment. I would now ask the applicant if they would like to speak.
Got some paper handouts and put some backup, but I think Paul is going to share the presentation I prepared today. I'm sorry, I only have 2, but just as a visual aid, everything will be up on the screen. I'm Jeremy Sutton, Pontiac Highland LLC.
Jeremy Sutton from Pontiac Highland LLC.
Okay. Thank you for this opportunity to speak, and I hope you all have an open mind, because I'm about to take you through a number of facts that are, you know, the public should be aware of. Everyone should have top of mind when these variances are considered, because really what happened is an absolute travesty, and I want to kind of speak to some of the facts, and I ask you to understand and sympathize with real facts. So we're going to kind of talk through those as we go today.
Can I just ask before you get started, do you have a sense of how long the presentation will be?
I'll try to finish it maybe in 20 minutes, if that's okay.
Yeah,
I'm not trying to make it. I just want to go through some key findings and facts that are really pertinent here.
Thank you.
Yep. Okay, Paul, if you can. Oh, thank you.
All right, if you just want to point at this one. This is front.
Okay, great, thank you.
This is back. All right,
Okay.
go.
So I read the packets that were distributed, and unfortunately, there's some very misleading information in the packets, and I'll put that to rest through some evidentiary inputs that I'll take you through today. There's a comment made in the packet that due to the building not being in conformance with the plans, and that's incredibly misleading. If you actually look at your own submittal in the city's records for March 30th, which was acknowledged to be received by the city and submitted to Bob Hudson, the building department plan reviewer. This is the actual design submittal under which the permit was generated on May 20th, 2020. The city does not contest that in their answer to the circuit court. The submitted plans clearly show the exact layout, roof lines, window configuration, sizing, 50 by 72, and the configuration of the home that would be built. Paul reinforced that today by looking at what you see on the right there. And if you go back through your records, in plan review, and with the building department, all of this was disclosed. So you can see a very close resemblance between the 2D wireframes from CAD that are shown there on the left in the center and the layout on the right with the photos that were provided in the packet. So it is misleading to say that it wasn't built in conformance. I actually went to extreme lengths to build it in conformance. And as you'll see with a lot of the evidence today, we've done everything that we could to make sure we followed the exact ordinance to a T, including numerous interactions with Donovan Smith, Vern Gustafson. So we'll explore some of that today. And actually the reasons for the stop work order were summarized in this letter, which was sent on August 21st, 2020. And it actually doesn't mention a disapproval of any inspection, and there's no mention of any variance required. It actually says that in this email, we have asked you, the permit is on hold. You are required to submit a certified plot plan from a registered surveyor. Plans are incomplete, but not limited to continuous 42-inch foundations or alternate, as well as your plans did not include the required concrete encased electrode for grounding the new electrical service. Where is the floor drain hooked into? The project is on hold until these items have been submitted for review and approval. So that was what was communicated by the city to Pontiac Highland Avenue LLC, which I'm a member of. So there was nothing on record to that effect. This is a timeline that we actually received through a FOIA, where Mike Wilson sent a summary to Rachel in 2020, and it actually shows no disapproved inspections related to the stop work order, only clarifications that are needed. So Mike Wilson provided this timeline you see here on the left, and you'll notice on or around 8/20 of 2022, when the stop work order is generated, it said reviewed plans submitted and approved, some inconsistencies required additional documents to clarify project. So there were no design changes. He asked for additional information to be specified related to foundations, concrete electrodes that are grounding out the electrical service panel. These are building infrastructure questions. So the project, and his note says, project placed on hold, waiting for additional document submittals for review and approval, which, by the way, we submitted within a week. And there was a point made during public comment that's been going on for 4 years. The stop work order has been in place for 4 years, and we have tried everything possible under the sun, hired different professionals, hired everybody we could, and even to this day, we still can't get the city to allow us to move forward despite all of the approvals that were provided over time. So I want to really zero in on a couple findings that are very eye-opening that we uncovered during FOIA looking through city communications. This is an email from Donovan Smith, the city planner, sent on September 6, 2022. And it's addressed to Kalfani Stevens, Deputy Mayor. Titles 404 Highland, Robert Bass, City Council comments. Deputy Mayor, the property is constructed and approved as a single-family home. However, the design is non-conventional and does appear to be an oversized garage and internally a home floor plan that meets the requirements of single-family homes, or single-family home requirements. The build was able to take advantage of the lack of design guidelines and standards for single-family home construction. There is a minimum square footage for homes of 1,200 square foot, and there is not a maximum. The home covers 3 parcels, totals 3,500 square feet. There was not a development agreement, variance, nor a rezoning for the proposed single-family home. The property is zoned R1 single-family and is a conforming property. Conforming property. I've discussed these items with Robert Bass in the previous weeks and years. Okay, the second finding, which was very, very eye-opening here. Letter from the Deputy Mayor Kalfani Stevens to Mayor Tim Grimel, and to the Honorable Council President, members of City Council. Executive highlights, September 11th. 404 Highland, there has been a lot of discussion and factually incorrect information spread about the property The following information is meant to only provide the city council with factual information and not to take a position as to what should or should not happen. The building is constructed on 3 lots and meets the lot coverage requirements of the city planning and zoning ordinances. The building meets the requirements of a single-family home. The building received the required clearance from the planning and zoning department. Very, very, very eye-opening communication. Now, I want to talk about prevailing case law. Michigan courts favor property owners that build under valid permits with approved plans. I'm just going to read you a court opinion from Kalkman versus the City Village of Douglas. There was a property owner who received, I'll just read it. In June 2008, Kalkman sued the city for improperly ordering him to cease construction. Specifically, he alleged that he had a vested right to build under the permit issued before the stop work order, and the city's order amounted to a regulatory taking. The parties cross-moved for summary disposition, and the trial court determined under the undisputed facts, Kalkman was entitled to judgment in his favor. The trial court concluded the zoning administrator had properly approved of his building permit, and that after Kalkman spent considerable amounts in reliance on the permit, he obtained a vested right to build under the permit. As such, the city's subsequent decision to order him to stop construction amounted to a temporary taking. Although the trial court entered into a we'll skip down the last sentence, the trial court held a bench trial on damages and ultimately found that the city owed Kalkman $178,000 in compensation. That's an opinion of a Michigan court. Dingman versus Algoma. Once a city or township issues a valid permit to an applicant, that applicant has every reason and right to rely thereon in his business dealings. So now we'll get into the detail of each of the variances so I can lay out for you facts pertinent to each variance for your consideration. On June 12th of 2020, which you can see the photo here inside of this Gmail, and you'll notice it was sent from me, Jeremy Sutton, to Donovan Smith on June 12th of 2020. And I'll just read it to Donovan. I think we are good with our actual setbacks, but I wanted to send you this email. We measured the structure off the back fences, which is the property line with the neighboring properties to the west. The building measures a 52-foot rear setback from the fence line. The building itself is 72 foot, not including the 1.5-foot roof overhang, which means that we have a resultant front setback of 26 feet. It's hard to discern exactly where the front property line starts without an incredibly accurate survey, but according to field dimensions of the rear fence lines from the property and neighbors, it appears we have a 26-foot front setback. Also, if you look at the following picture, our front setback is larger than the neighboring house. I took this photo with the posts lined up, and you can see the neighboring home is about 5 foot closer to the street. I assume we are good to continue without issue. Thank you. I called Donovan after this issue, and he just made me aware that, in the state of construction, they will review that and take that under consideration. A week later, knowing ahead of time that the location post could possibly be in the setback, that's the reason why I sent the email, the city approved the post hole inspection on June 18th, 2020 with the southeastern posts in the encroaching position. So there's the note from Mike Wilson's file, building post hole inspection approved, 6/8/2020, a week later. Relying on the building department post hole inspection, we spent over $90,000 on the home between June 18th, 2020 and August 20th, 2020 in reliance on the approved post location. No issue is ever raised by the building department or planning department about the setback before these significant expenditures. In fact, the city also approved a framing inspection on August 20th, 2020, one day before the stop work order was issued. Okay, so Mike Wilson started describing to me in 2021 that this was a self-inflicted issue. And I just want to clarify, even while the 1 foot setback request is technically accurate, 60% of the front facade of the house, because it's on an angle to the property line, is actually behind the 25-foot setback. So the actual encroaching position, I'm going to walk to the screen here. The actual encroaching position on the 25-foot survey is from this point to this corner. So it's about 16 feet. So it's a pizza slice. And it starts at 0 inches, and it tapers to 12 inches. So it's not the actual whole front facade is 1 foot in the setback. It is a small self-inflicted wound when the posts were set, which were then approved by the city. So Mike Wilson had told me that they can look past that issue, and you'll notice in all communications that, including the October 12, 2022 officer hearing meeting, there was a comment made that as soon as a revised plot plan is submitted and approved, Pontiac Highland will be back at it. There's no reference to the setback issue, meaning the city had no issue with it to complete the home. Okay, so how did this issue come up? On May 11th, 2023, only after over 2 years, almost 3 years, after the city was aware of the setback encroachment, a citation for the front setback gets issued in an effort to create a tactic to take the building down in an attempt to also erase the errors that came at a grave cost to me as the permit holder on behalf of Pontiac Highland. There's also another interesting finding here too, is that there's also an established building pattern on Highland. And if you're familiar with Highland, near the visual Paul shared with us, there's not many homes on that immediate street adjacent to M1 Concourse. I believe there's 4 homes or 5 homes. And there's a lot of space in between those homes. None of them have design consistency. They're all different, probably different builders, different designers, different years of construction. And it appears that the house immediately to the south, based on looking at satellite images, is around 23 feet of a setback. And I know that your ordinance also provides allowances due to building patterns, meaning this pattern could also be considered in this variance should you choose to do so. Now, this leads me to the significant hardship for variance number 1. 404 Highland is built on post-frame construction, which is gaining a lot of steam, a lot of momentum today for its cost effectiveness, its flexibility in design. Open floor plans makes it very, very well suited for modern residences. It leverages post frame, making the southeast 6x6 post critical to the structure of the home that supports the actual roof trusses. In fact, over 4 posts are impacted in that pizza slice, meaning that a modification will require extensive demolition, new foundations and footing, new roof trusses, and a whole structural engineering exercise to make the entire roof structure package work. Initial construction calculations are on the magnitude of $35,000 to move the 4 posts and rebuild the front of the home. Okay, this is, again, after city inspected, improved the post hole locations of the exact posts that are in question right now. Variance number 2, the attached garage. Now, this one has probably an hour's worth of factual evidentiary support behind it, but I'm going to try to keep this pretty short and pretty sweet. Donovan Smith so before even the parcels were purchased, I was looking into buying some parcels in the city of Pontiac, met with the city to understand the R1 zoning ordinance, because I knew that was part of what those parcels were. And Donovan Smith, on January 4th of 2020, sent Pontiac Highland Avenue LLC all design guidelines in effect on January of 2020. You can see at this time no reference to garage or attached accessory structure maximums. And I think you'll find that your reference to your 800 square feet was adopted well after this permit was issued. And you'll notice that in a communication that Donovan sent, this is between Donovan Smith and Vern Gustafson, the old planning manager, I'm going to show you that the proposed home was reviewed against the design ordinance, section 2.304R1, R1A, R1B, one-family residential dwelling districts, and section 2.404 common yards. The applicant was given directions for plan resubmission prior to the submission of building plans. Reduce the overall size of the proposed structure. And by the way, this was the original submittal that was larger than 3,600 square feet. Reduce the overall size to provide greater setbacks from the property lines, provide a housing design that emulates the appearance and function of a single-family home, interior living space be increased to 1,200 square foot. Then his comment, which is incredibly important on the bottom, the owner submitted to planning around March 15th plans for a single-family home for a total of 3,600 square feet and compliance with the above review criteria for zoning. The applicant was encouraged to submit construction plans and plot surveys to the building department for plan review for a building permit. So he actually used the ordinances in effect at that time, documents it here to know that it's indisputable that that was done according to plan. The approval was granted against the ordinances in effect at the time. So all changes were accommodated, spent a lot of money on architectural fees, engineering fees to do exactly what the city had. And resultant, here's the resultant email. plans from Donovan Smith to Jeremy Sutton and Vern Gustafson. Vern's very senior tenured, very experienced. Jeremy, the planning division will accept your submitted preliminary concept design for a residential home construction at 3,600 square feet, 100 wide and 150 deep lot, 72 by 50 construction, so 72 by 50 building mass at 404 Highland. Please proceed with the submission of the formal plot survey and the lot configuration documents. So, as the process in the city works, which I educated Pontiac Highland Avenue myself on, we then took the plans and submitted them to the building department, which is in the same room as the zoning and planning department here in City Hall. So building department plan reviewer Bob Hudson completed a plan review and requested changes on March 26, 2020. Those are his comments. And interestingly enough, in the bottom right, it says approved as drawn. What I want you to zero in on is 1,220 square foot, single family home and attached garage. So all city documents support that there is a 2,300 square foot garage approved as part of the plans that generated the building permit. That's undisputed. These records were made and recorded as received by the city of Pontiac on March 31st. So the original email that I showed you to Bob Hudson at the outset of this presentation is exactly those set of plans, which we have here on file. We can review them sheet by sheet if you'd like to. The plans were then approved again on that March 31st submittal and received, and they were approved on April 7th of 2022 again, so a secondary approval. This is, again, what we built. Exactly what's laid out in the plans that were submitted on March 30th, which constitutes the full submittal from the city. This matches the home that was built in massing, layout, and configuration. That's the home you see in the photos. Permit issuance. Let's just recap on this. Building department issued a building permit on May 22nd, 2020. In reliance on this permit, the received approved print submittal on March 31st, we proceeded to build the home. It is documented in numerous correspondences that the home received the necessary planning and zoning approvals, the home is a conforming residence, and met the design standards for residential homes. So what's also misleading in the packet is that there was, in fact, and it's undisputed, that there was a 2,300 square foot attached garage approved as part of those plans. So technically, we're here for variance today because the city has argued that in their defenses, that saying that we didn't exhaust our ZBA opportunity, but in effect, we're asking, basically this was approved almost 4 years ago, okay? So here we are today, and as you would probably know, the variances are very well different. We found in discovery that residential design standards were changed on or around, I believe it was October of 2020, likely in relation to our property after the fact and after the stop work order was generated. Very, very interesting finding. To alter, okay, so let's just talk about this hardship because it is significant. To alter the residence to new design guidelines, which weren't in effect in 2020 during plan review and approval, the residence would have to be partially torn down and rebuilt from the ground up, not to mention a significant and material change in the intended preferences and usage of the home. Reconfiguration costs would likely be six figures and materially change the investment and value in the property. Providing a variance, you're empowered to do this tonight. Providing a variance could conceivably cure this issue as a whole, in effect resolving and drawing closure to the design approvals that were undeniably made in 2020. Your variances can cure. What transpired has been a travesty to an aspiring property owner in the city of Pontiac. These parcels weren't even purchased until we got clearance from zoning to move forward with this idea. Your understanding and sympathy to the actual facts would be most appreciated in this case. Taking a step in the right direction to resolve this matter would be the right thing to do. You can probably appreciate the fact that so much money was invested in this property to enhance, the value of the neighborhood. I feel that it does so. The city has quietly hired municipal advisors and have two law firms under retainer using taxpayer money to try to make this issue go away. I want you to understand from our point of view, because of the fact pattern and how confident we are in what we've done, Pontiac Highland Avenue will be resilient and rely upon the court should we not be able to settle this matter. And by the way, we've issued some settlement proposals that we haven't heard back on yet from the city. That's a little disheartening, but we're trying to move everything forward to try to get this project done. Pontiac Highland Avenue LLC asks you to do what is right. that any homeowner would want, that invested in a property that they built and they put their sweat, blood, and tears into. Please approve of these variances so the home can be moved to completion under the standards it was approved upon in 2020. And I'm more than welcome to have you look at those prints from that March 30th submittal. And I thank you for your time. I hope this has provided a little bit of clarity, because we'll go back to Mayor Scalfani-Stevens' quote. There is a lot of misinformation on this property. And this was an opportunity for me to show you through exhibits that we found in discovery what the real actual facts are pertaining to the matter, right? And I think Calfani hit the nail on the head when he said there's been a lot of factually incorrect information spread about this property. And it just goes to reinforce the building received the required clearance from the Planning and Zoning Department, and you saw that Donovan Smith and Vern Gustafson approved of it under the ordinances at the time. So thank you for the opportunity to speak on the property. I'm hoping we can work together and get this done.
Okay, thank you. Before we start deliberation, I do have a question of the administration. I just want confirmation that the ordinance that we're stating that this structure is not in compliance with, that it was in place prior to the applicant submitting their application and has been consistent through to this day.
Sure, that zoning ordinance was approved in 2012.
2012. Do we have can we get a reading of that, or can you confirm exactly what it is that you're saying is non-compliant?
In relation to the 800 square foot, well, right now we know that that ordinance was approved in 2012. Okay, I can't be 100% sure that the 800 is in there, but I'm pretty sure that in 2012 the zoning ordinance was approved with a lot of standards in the relation to the accessory and detached structures.
Can I clarify that answer? Did you say the 800 square foot was approved in 2012?
That's not what he said. He said the ordinance was approved in 2012.
And specifically what ordinance?
The zoning ordinance.
Okay. Do I get rebuttal?
No, we're going to deliberate at this point.
Yeah, we're
Okay.
not going to go back and forth with this.
I guess we'll open it up to deliberation by the board members. Is there any questions? From the board members, yeah.
Oh, boy.
Can-
Mike,
And let's try to limit it to questions regarding the standards.
I got questions. Was reading under here is that the house was the house built to the structure that the planning board approved?
Yes, the house is materially similar to the March 30th plans.
And when you built this structure, did you see any house in that whole area that looked like what you were building?
I believe no home has been built in that street, in that specific street area for probably at least 40 or 50 years, and all the homes are different in design. I could be wrong. I didn't look at property records, but they're all different.
And is this case in court?
Yes, it's in two courts, as Paul pointed out. Circuit Court and then also District Court.
Who's the judge in 50th District Court?
Sorry, is it Judge Walker?
Walker.
Walker, yep.
That was pregnant to asking that question because my better half is a court recorder at 50th District Court, so I'm gonna have to abstain on the vote. So I don't want to be a conflict of interest, but I do have some more questions to ask. One more questions. What?
Are you asking the commission to recuse you? Because, and that's fine.
I'm gonna do it myself.
I know, but you shouldn't ask questions. You shouldn't participate in the discussion if you think there's a conflict.
Okay, well, don't ask any more questions then, right?
I think so.
Okay.
I don't know if there's a conflict, but,
I'll take your advice. I won't
Okay.
ask any more questions.
all right,
That's what you're here for, right?
yeah, I think.
Anyone else with questions or comments?
Go ahead. I'll start off. Just briefly on the site plan, the garage doors, they don't look like they're 8 feet tall. So they're massive. I don't know what kind of doors you're doing, but can you explain a little further what you're planning on doing? Is this going to be somebody's house? Is this a business? Why such a large garage?
Yeah, those are in fact 8-foot tall garage doors. Purchased them from Menards in Bloomfield Hills, just adjacent to where the house is. They're marketed as residential garage doors. You know, they're kind of on trend, if you will, right now. You know, I've seen them in many other municipalities. So, you know, as the complaint is laid out, I'm a motorsports aficionado, and I have a small car collection, and you know, there's no limitations, you know, as a property owner in the state of Michigan on what interests and hobbies you can pursue in your own home, as long as it's in effect with an ordinance that may not prohibit the otherwise. So there's no commercial operation at this house. It's simply a residence that's a secondary dwelling that has, you know, 2 bedrooms. It actually is proposed to be 2 baths as part of a settlement offer. So it's expanded on that footprint, and it is designed to be used as a secondary dwelling. I do have an interest in cars as a hobby, and you know, that was something we checked out. And even Donovan Smith, in early conversations in 2020, said this looks like an amazing kind of man cave, if you will. You know, he even commented on that as a residence. So it was abundantly clear what the purpose was at that time.
Other question regarding the first issue regarding the zone, the setback. You typically have the property surveyed and laid out, you know, professionally. What went wrong?
It's actually an interesting question. So we submitted a plot plan on the document submittals. It wasn't a surveyed plot plan. It was a plot plan. What's interesting is on the residential design guideline packet the city of Pontiac had at the time, they ask you to draw in a plot plan on a grid on a piece of paper, right? So you have to assume that means, okay, you can fashion a plot plan, which we did. We drew it in CAD, in AutoCAD, and submitted that, signed and sealed. And you'll notice in that email from Donovan Smith, a survey was not done to post the corner markers of the building at that time. But the city didn't require it, right? It was moved through all the approvals without it, and we didn't have a survey done. We looked at where the property sat. We looked at the abutting homes and the building pattern in the neighborhood. We knew the ordinance per Donovan was 25 foot, and we built off of that. It was a miscalculation, maybe of the builder where he set the post, but again, it was put in that position, and to be abundantly clear, made the city fully aware of the post location. There could be a setback issue, passed with flying colors, and in reliance on that approval, spent another $90,000 from the framing out.
I thought my understanding for staff that when you do new construction, that you had to have, you know, a surveyed property on that. Is that not a fact?
We asked for surveys.
I beg your pardon?
We asked for surveys.
You asked for surveys? And
Yeah. Now we ask for surveys, yes, we do. Yeah.
Also, my understanding from post-soil inspections was the city doesn't do the survey. I don't know if it's changed now, but they don't do the surveys. They just look at the hole, make sure it's deep enough, and that, so to speak. I don't know if things have changed now, but that's the way it was. But
Yeah, I mean, that's why I sent this communication.
Within the guidelines. Now, I know stuff happens during construction and so forth, and as you mentioned, you only have a portion that's not within the variance. Regarding the second comment, as board members know, when it comes to oversized garages, nothing, I very seldom approve oversized garages in the R1 zone unless there's something special.
Okay.
Now, I have granted oversized garages, but nothing that's, you know, nearly 2 times the size of the residential area. Now,
Did you ever have the?
I know there's issues in this in court, but finding the facts from administration or, you know, of planning commissioners or, excuse me, from city staff or something like this, not binding on the ZBA decision-making. So where they got the idea that you could build, you know, this 1,200 square feet home with a 2,400 square feet garage, I don't know. I've been here a long time. That it's okay without getting coming through the ZBA first and getting those type of approvals up front before you build.
Sure. Are you familiar with Vern Gustafson?
Yes.
The planning manager at the time?
Right.
So he approved of it with Donovan Smith, the primary city planner. Vern is very experienced. He's been in the municipal zoning business a long time, and he approved of this. It's interesting that he would never have raised, if such an ordinance was in place, the issue with the massing of the attached garage, because he's very, very experienced and very tenured.
Thank you. That's all regarding my comments.
Anybody else have any questions or comments for administration or applicant?
No comment.
Yeah, I do. I have a couple. So this is in court, correct?
Yes, sir.
In two courts.
Two courts.
And you're asking us to make a decision when something is in the middle of two courts without a decision from the court.
Yeah, so the defense raised an argument that I believe we didn't exhaust all options, which would have been the final last resort is maybe a variance from the ZBA. So as Greg Need, our attorney, stipulated in the application, that's partially why we're here, part of why we're here today.
Yeah, another concern I have is the facts don't even line up from side to side. See, I read this and then you tell me something completely contrary to all of this packet I just read.
There's very few exhibits in the packet.
Through the chair, can I make a comment? Actually, yes. In 2012, the 800 square foot accessory structure square footage was in place in 2012.
Was in place in 2012.
Yes, when the zoning ordinance was approved, yes.
Thank you for clarifying that. Yeah, again, I'd just like us to try to concentrate on the 7 standards on this. You know, we've got variances in front of us. We need to look at, you know, whether we as a board feel they should be granted or not based on the standards. And I think that let's just try to keep our focus on that. And are there any other questions and or comments from the board?
I can't comment on anything.
Not if you're gonna, no, not as, since you recused yourself.
Oh, okay, okay. I'm listening to my attorney over here.
Okay, so Paul, the 800, based on the standard and the way the code is written, it's the lesser of three things, and 800 square feet being.
800 square feet is a max for an accessory structure in the city of Pontiac.
Okay, I just wanted to make sure we were absolutely clear on
You are
that
correct.
point, and that was in effect as of 2012.
You are correct,
So in effect,
2012.
at the time all of this
Yep.
was going on.
When the ordinance was drafted, yes, it was.
Okay, and approved in effect in 2012.
Yes, you're correct.
Okay, just want to make sure. Okay, thank you.
It sounds like we're pretty much exhausted comments and questions in our deliberation. Is there a motion on the first issue? The setback issue?
Are you putting those back up, Paul? Okay, thank you. I can't find them in my packet.
They can be found on page 10 to consider sample motions.
Looking for a motion from the board.
I'm going to require a motion from the board, yeah?
I move to deny the dimensional variance for an accessory structure located 24 feet from the front property line at 404 Highland Avenue based on the following finding of facts, that it does not meet the standard based on the facts.
I second.
So we've got a motion from McClellan and a second from May. Is there any discussion on the motion specifically? No discussion. Roll call, please.
Burke,
It's a motion to deny.
Motion to deny.
motion to deny.
So I agree.
You agree to deny?
Yes would be.
Okay. Bueno,
No.
Bavacqua,
No.
Kirkendall,
Yes.
McClellan,
Yes.
May.
Yes.
Motion passes.
You haven't asked me.
You, that's right. So do we have a motion on the second issue?
The second one, I motion to deny dimensional variance for the accessory structure of 2,307 square feet at 404 Highland Avenue based on the following findings of facts. It does not meet the standard based on that fact.
I second.
So we've got a motion by Kirkendall and a second by May. Is there any discussion on the motion? Seeing none, we'll roll call.
Burke,
Yes.
Bueno,
Yes.
Bavacqua,
Yes.
Kirkendall,
Yes.
McClellan,
Yes.
May.
Yes.
Motion passes.
Thank you. Next item on the agenda is new business. Do we have any new business?
There is no new business at this time.
And general public comment opening. Is there anybody who would like to make a public comment?
Robert Bass again, Assistant District Counsel. I just want to thank the commission. And two, I want to just briefly make note that I would never come before this body or our honorable council body or any of you and directly lie to you with the people that follow me. So if this document's a lie and it was written by everybody that he named, then yes, Robert Bass is a liar, because everything that the city sent me is what we had a discussion about. And I am a contractor, and I know you cannot eyeball how you're going to put up a building and be successful. Thank you very much for your time.
Yeah. Carlton Jones, 1323 Oakland Drive. I want to say to the point that was made by the board member who said that what the planning commission does or the planners has no bearing upon what you do. I think that is a great thing, because we can't always control with people who we hire to do the right thing, especially when it becomes a zoning issue. Zoning is so important in our city. For us who live there full-time, raising our family, we enjoy having some toys. But when we have an R1 district, I hope that not only just this case, but throughout the city, that you are very conscientious of protecting R1, because we have a lot of that going on right now in our city. Yes, we have a lot of empty lots, but I'll tell you, two wrongs don't make a right. Thank you.
Any other public comment? Seeing none, we'll close public comment. Next item is miscellaneous. Do we have any miscellaneous?
No miscellaneous.
Anyone on the board?
Yeah, I would like to thanks for having my attorney here. Everybody know to keep my mouth shut, it wasn't easy, so I had to zip it. So, and thanks for the water.
Any other miscellaneous? All right, we're moving on to staff communications.
Staff would like to acknowledge Mr. Dan Kelly for attending today's ZBA meeting. Thank you very much. Also, the next ZBA meeting will be held Monday, May 20th at 6:30 p.m.
All right. Move on to adjournment. Can I get a motion to adjourn?
Move.
Second. You were waiting on that.
So we got a motion. All those in favor say aye.
Aye.
Ayes have it.